Professor Sastry, a very good morning to you and other dignitaries. Myself, Professor Dr. Bodhisattva Acharya. And
good morning.
Sir,
good morning to one and all.
Fine, sir. Thank you, sir.
You are in comfortable zone, Professor Bhatnagar, whereas I am in the hot, cold place.
Right.
Wearing all the sweaters, jackets, everything.
Jackets, yes.
But sir, in Jharkhand, it's very hot now.
Yeah.
Yes.
But it is cold here.
Yeah. I can understand, sir.
Let me keep water.
Good morning, everyone. So we will be just starting in a while. I hope everyone is here, and I would request everyone to turn on their cameras and keep their mics off. Thank you, everyone. So we will be starting now. A very warm good morning to all the distinguished guests, speakers, and participants present here. I, Sacha Kavich, on behalf of the Seminar Committee of Dr. Ram Manohar Lohiya, National Law University, Lucknow, would like to extend a hearty welcome to each one of you to the inaugural ceremony of the two-day national seminar on emerging issues in law and justice in the perspective of globalization, supported by Department of Higher Education, Government of Uttar Pradesh. Globalization is incredibly efficient, but also so far incredibly unjust, says Pascal Lamy. In modern globalization times, as nations evolve rapidly, there is an increasing discussion concerning the notion of law and justice. So we at Ram Manohar Lohiya National Law University, through years and seminars, have always worked with the rock-solid aim of providing the best experience to all our attendees. So here, we bring to you the national seminar that would provide all the attendees a level field knowledge of the intricacies and nuances of contemporary law and justice issues in an ever-expanding and globalizing world. So this national seminar is a two-day event with 4 brainstorming technical sessions. All the participants would be provided the opportunity to showcase and present their research papers in the technical sessions. Now, we would like to welcome our Honorable Vice-Chancellor, Sir, Dr. Subir K. Bhatnagar. We would also like to welcome Dr. Visalakshi, our Head of Department, and Dr. Prem Kumar Gautam, the Chairperson of the Seminar Committee. We would also like to take this golden opportunity to welcome Professor T.S.N. Sastry, Founder Vice-Chancellor, Sikkim National Law University, for the keynote address. We welcome you, sir, and are glad to be able to host you. Through this platform, we would like to welcome and extend warm gratitude to Justice A.R. Masoodi, sir, Judge at the Lucknow bench of the Allahabad High Court, who was our guest speaker. However, sir would not be able to join today due to some supernuous reasons. Now, we would like to call upon Vice-Chancellor, sir, to enlighten us all with his words of wisdom and inaugurate the ceremony. Over to you, sir.
Thank you very much. Very good morning to everyone. Professor Sastry. First of all, I must congratulate the seminar committee for choosing this particular topic, emerging issues on law and justice in the globalizing world. Now, this particular theme is open to many interpretations. We can go in international law, constitutional law, and other fields of law and political science. But one thing we have to accept, that it is focused on globalization. That is, in other words, we can say we are going to talk about law and justice in the globalized world. The world is being globalized. Now, when we talk about globalization or global world or globalized world, that doesn't mean that the political boundaries are demolished. The political boundaries of different nations, countries remain intact. Then what are being demolished? The trade barriers are removed. They have been demolished. So in a way, when we look at the demolition of the trade barriers, that there will be free flow of trade and commerce. Like, you know, under the Constitution of India, Article 301 is there, which talks about that the freedom of trade and commerce and intercourse shall be free throughout the territory of India. In a way, we are trying to tell that the state's boundaries will remain intact, but there will be one economic market. So likewise here also, when we are talking about globalization, that means the boundaries are being demolished, not the political boundaries, but the trade boundaries. That means that we are not creating a global village. We are creating a global market. The market is being expanded. The community is not being expanded. So we have a village. Here in India, it may be there. But when we are talking about world as a whole, then we are not having a politically united global village. It's market. And the difference between market and village is that the village is based on love, affection, harmony, and compassion. How they are united, bonded, fraternity, bandhutvam, bondage. The norms of bondage are compassion, harmony, empathy. There are so many linkages. But in global market, you will find whether it is global market or market within a country, domestic market. Market is very cruel. That's why market needs to be regulated. So when we look at the international market, that is which has come in the wake of globalization, and by globalization we mean privatization and liberalization. That is, economy is liberalized and the private sector is allowed to come in the market as far as possible, to a maximum extent, you can say. So how the global market will be regulated? Because no market is free. Whenever somebody is free market, it's wrong. Market is always regulated. The market in India, in Lucknow is regulated. And you have seen in COVID-19, during this pandemic, that the market was also regulated, that you can open on these days or you can open only one side odd, and even all these things you have seen. The taxes are imposed, fee are imposed. There are so many things which happen. So we can say comparatively that the American market is free if we compare it with China or India. But the market is never free. So international market, or we may call it global market, it could not be free. So there are various agencies, international monitoring or regulating agencies have come up. WTO, World Trade Organization, IMF, International Monetary Fund, World Bank. There are many agencies which are regulating, controlling, and dictating sometimes their terms to the market players. Now, these bodies like WTO, IMF, and World Bank, they are dominated by the developed countries. And it happens in market also, in domestic market also. The powerful will dominate. The weaker will agree. That happens. Now, who is stronger, who is weaker, that's a different thing. It may be because of the rules also, that the rules are so made that X party becomes stronger and Y becomes weaker. So rules create this kind of strength of weakness. So in all these international fora, WTO, IMF, World Bank, the developed countries are ruling and they formulate the rules, regulations, structures. And these rules, regulations, and structures are biased. They are tilted in favor of the developed countries. Consequently, what has happened? That it has impacted the domestic market also. So why we are discussing globalization today? Because globalization has impacted the lives of the common people in the developing countries and the market also. And if the market is affected, it is regulated, it is controlled, then the lives of the common people are always affected. There is no denial in this particular fact. Now, how it has impacted India? Now, excuse me. In India, we have a constitutional democracy, unlike Chinese system of governance. We have directive principles of state policy. Now, directive principles of state policy, they promise a what you may call constitution of a welfare state. You can say it also promises to constitute a socialist state, because you have in the preamble, we the people of India having solemnly resolved to constitute India into, and then there is a term socialist that was added in 1976. That's a different thing. We have in our preamble that we are making this constitution to promote fraternity. Fraternity is a very important word. And this fraternity is translated into fundamental duties also. If you look at the fundamental duties, you will find the words like brotherhood, compassion, they are being used to create a kind of a feeling which you may call the feeling of fellow beings, or we belong to India or India belongs to us, like that. In fundamental rights also, there is a very specific article, Article 23, talks about exploitation, that there will be no exploitation. So in the village or in the market, there will be no exploitation. This is our constitution. So it is tilted in favor of the masses, because no constitution can be neutral. It's always values loaded with values. And we have values in preamble also, translated into fundamental rights, and also in the fundamental duties, and in the directive principle of state policy. And directive principle of state policy impose, if I can say so, duties which are fundamental in governance. Now, how India or the governments of different states could implement directive principle of state policy when globalization wanted something else? It was going in opposite direction. So despite, right to education, that was recognized by the Supreme Court in 1992, when you can say globalization had just started, at least in India. The court cannot go into the policy decisions. This is the, you can say, limitation that is imposed under the constitution, that is separation of powers. Now, the theme of this seminar is focusing on emerging issues. So when we are talking about emerging issues, what is at this point of time emergent before our eyes? That is pandemic, COVID-19 pandemic. And during COVID-19 pandemic, you have seen WHO, World Health Organization, collapsed, virtually collapsed. It could not do anything, despite the fact that it had enormous powers. And to make the things worse, the United States of America threatened to withdraw its grants. So that kind of a globalization withered away, started withering away. And in place of that globalization, if I can use the term, deglobalization started. Because United States of America started what you call in international law terminology, trade law terminology, protectionism. It started protecting its own workers, services, and products. What happened in India? Due to globalization, different markets have emerged in different places. Say, for example, Mumbai, Bangalore, in Gujarat. And they were mainly manufacturing industries. From there, because of lockdown, these factories or companies were closed, and migrant workers started migrating to their home states. And when migrant workers were going back to their homes, what did we see in India? We saw in India that the federation started collapsing. Now, for example, the people were moving from Maharashtra to UP. The Maharashtra government was not responsible for that. But why should we go for that? Because they are not our domiciled citizens. UP, Bihar saying that what can we do? We can't do anything. The central government should come in play. And nothing was happening, and they moved on foot. And many people, migrant workers, died also. So why it was so? On the one hand, nobody was taking the responsibility of the migrant workers. On the other hand, I am talking in reference to federalism. The powers of the center grew in strength because of the National Disaster Act. So that federalism collapsed because of one act that gave enormous powers to impose lockdowns and do many other things also under the Disaster Act, National Disaster Act. So that what you call centralization started. And then comes another unique feature of this globalization. Vaccine nationalism started. Now, the developed countries were producing vaccines, but they were not prepared to give them to the developing countries. And even the developing countries, for example, India was forced to give vaccines to different countries. We could not control our production or distribution also. And this happened. So when all these things were happening, the Indian government was also not prepared to give vaccine free to the poor masses. It was only because of the Supreme Court that it intervened. And the Supreme Court and High Courts, they intervene and they provide some kind of succor and relief to the poor masses. So what we have seen in last 2-3 years, not 2-3 years, 2 years, you can say, during pandemic, because I refer to this pandemic because the theme is emerging issues. So nothing is there on our mind or before us, only pandemic. That is affecting right to education, right to health, right to development, and our federalism also. These are the basic things which I want to convey to you. But again, I may give a sound, you can say a note of caution that this is not the only interpretation which I have put up before you, because there are many interpretations. Professor Sastry and or other fellow colleagues will be presenting different aspects of this particular theme, because it is a very wide theme. It has vast area, and anything under the sun can be discussed here under this theme. So that was my take, and I again congratulate the seminar team, Dr. P.K. Gautam, and I'm thankful to government of UP for giving us this grant, and again thankful to Professor T.S. and Shastri for accepting our invitation. Thank you very much. Over to you.
Thank you, sir. That was really insightful. We would now like to invite Dr. Visa Lakshmi ma'am to share her views. Over to you, ma'am.
Thank you, Sachika. Honorable Vice-chancellor, Dr. RMLNLU, Professor S.K. Bhatnagar. Honorable Vice-chancellor, NLU Sikkim, Professor T.S.N. Sastry. Respected Professor Bodhisattva Acharya, Seminar Committee Chairperson, Dr. P.K. Gautam, Seminar Committee Convener, Joint Secretaries, 20 members of this committee, my dear participants, namaste, good morning. Seminar Committee of RMLNLU is organizing today a national seminar on a very precious contemporary issue, that is emerging issues in law and justice in the perspectives of globalization. Relating to having regard to the title of this seminar, just I want to speak few points relating to business and human rights in the era of globalization.
Unmute yourself. Unmute.
Yeah. This slide will just be- Yeah. Yeah, sorry for inconvenience. The last decade has witnessed the emergence of new human rights standards to be observed and complied with by business houses and corporations. In the new world order, where we are exploring global justice issues, it is expected that corporations observe national and international hard laws of human rights and respect global standards. Business and human rights, PHR, is evolving as a new concept for addressing the infringement of human rights in business activities. In 2011, for the first time, the United Nations placed responsibilities on the corporate sector by promulgating business and human rights general principles. The United Nations Guiding Principles on Business and Human Rights, UNGP-BHR, were accepted by the Human Rights Council and obligates corporations to observe and respect human rights while carrying out their business activities. UNGP provides a protect, respect, and remedy framework. UNGP guidelines mandate states to prepare a national action plan for implementing the idea behind it. Many countries have published their national action plans, but the majority of them focused on corporate social responsibility. As we know, in international law, the state is a primary duty bearer for the protection, respect, and provision of a remedy for human rights infringement. Through UNGP, a new concept has been developed to make the corporate sector respect human rights in their activities. Globalization helps the corporate to extend their networks and operations across national boundaries in a global market. CSR requires that whatever companies have absorbed from society, they need to pay back. CSR only places a legal duty on the corporate to invest in the socio-economic growth of the people or the country. Whereas BHR is all about the businesses taking responsibility for their own conduct and their responsibility for the human rights of the community, their employees, labor, and environment, etc. UNGPs are broadly based on 3 pillars. Pillar 1 deals with the state duty to protect human rights. Pillar 2 provides for the corporate responsibility to respect human rights. Pillar 3 is based on access to remedy. Pillar 2 of UNGPs deals with the responsibility of business to respect human rights in their operations. India has already published a zero draft plan on business and human rights. In this plan, government had discussed the existing legal system, policy, and programs for businesses' responsibility towards human rights. In India's NAP, 9 principles have been adopted as national guidelines on responsible business conduct. These guidelines elucidate principles to be followed by the businesses. Out of 9, these are very significant. Principle 3, businesses should promote the well-being of all employees, including those in their value chains. Principle 5, businesses should respect and promote human rights. Principle 6 deals with businesses should respect, protect, and make efforts to restore the environment. Similarly, Principle 9 provides for businesses should engage with and provide value to their customers and consumers in a responsible manner. Principle 5 of 2018 National Guidelines on Responsible Business Conduct suggests that businesses should put in place policies, processes, and structures that demonstrate respect for human rights. Such processes must include the responsibility to conduct human rights due diligence in order to identify, prevent, mitigate, and account for how they address adverse human rights impacts. The principle urges businesses to be especially responsive to those persons who are most vulnerable to or at risk of such adverse human rights impacts. Additionally, it requires businesses to promote the awareness and realization of human rights across its value chain. India has made CSR mandatory under Section 135 of the Companies Act 2013. Several amendments were already made. Gandhian principle of trusteeship is envisaged in the proposed Zero Plan. The Ministry of Corporate Affairs has also initiated Social Responsibility Data Portal, a platform for a dissemination of CSR data and information filed by the companies. MCA has An Indian Industry Association has also released a voluntary code of conduct that may be adopted by its member companies. Amongst other things, the code of conduct deals with prohibition of bribery in all dealings by the company and compliance with anti-money laundering laws, prohibition of discrimination, prevention of sexual harassment, promotion of social welfare activities, and sustainability to minimize the adverse impact of a company's operations on the environment. The Institute of Company Secretary adopted by the private sector. Pillar 3 stresses and specifies the need to ensure better access to remedy for victims of business-related human rights abuses as a responsibility of both the state and the businesses. State-based judicial, quasi-judicial mechanisms are open to redress human rights violations. So, few remarks or concluding remarks are India's NAP should incorporate two core duties on the businesses. Number one, avoid infringement of human rights. Number two, address adverse human rights impact. NAP should cover a fundamental ethos of BHR, which expects a policy commitment from companies and that must be available on a public platform. This should include awareness regarding rights, grievance mechanisms, and remedial mechanisms. It is essential to keep a smart mix of voluntary and mandatory provisions in NAP, so as to create a level playing field for companies for mandating necessary minimums such as mandatory human rights due diligence mechanism. Thank you. Thank you, one and all. And congratulations, the convener of seminar, chairperson of seminar committee, Dr. P.K. Gautam, and all the members of seminar committee. And similarly, I thank all the organizers, convener, joint secretaries, and members of seminar committee for your endeavor to organize very precious program today. Thank you. Thank you, one and all. Namaste.
Thank you, ma'am. We are now glad and delighted to invite our keynote speaker, Professor T.S.N. Sastry, sir, to enlighten the gathering with his wise words. Over to you, sir.
Professor Sastry, I am sorry that my camera is not responding.
Yeah. Good
Don't
morning.
take it otherwise, please.
Yeah. Good morning to one and all at the outset. Honorable Justice Masoodi, Honorable Professor Bhatnagar, the HOD, Madam Visalakshi, Dr. Prem Kumar Gautam, and other organizing seminar members, participants, my own students across the country, and particularly my own student, Dr. Sadiq Syed, the UN ambassador from Africa, who joins most of my lectures, and Professor Acharya from Jharkhand. I'm extremely happy and thankful to Professor Bhatnagar and the team for giving me the opportunity to share few of my views on a very important topic. In fact, yesterday when talking to Professor Bhatnagar, he told me, I've chosen, Professor, you are, because the topic is so close to you. And as I'm working on the topic since long and delivering lectures at various universities across the globe on various perspectives of law and justice. Well, emerging issues is a good title, there's no doubt. But for law and justice in globalized world, issues are not going to emerge at any point of time. Issues that have emerged have to be addressed. This is the conception of law and justice in a globalized world. Well, I will not speak much. I will not take hours together because I'm not exaggerating the topic being so fascinating to me. If I start speaking on this, it may go even 2-3 hours. I'll restrict myself to the time limit, but I'll touch 3 important perspectives. That first, to explain the conjunction of law and justice, and then globalization, then coming to the perspectives of globalization and the significance of law and justice, whether achieved or failed by the nation states, both at the municipal level and the international level. These are the three important perspectives that I will be concentrating. As we all know, law and justice, though have no definite meaning and ideologies, they have a wider connotation in socio-economic cultural perspective in the world, in view of the varied cultures that have there everywhere, because the legal system of each country and that of international law differs basing on cultural perceptions of mixtures of socio-economic, political, cultural considerations. Well, that being the important issue, law and justice are considered as divinical aspects all over the world, right from ancient to modern times, except the positivist period of John Austin. Well, it is the divinical origins also have not realized the divinical fruits by member states and the individuals, because we fail to understand the divinical significance of religion and the birth that we have taken as humankind. Unfortunately, these two aspects have been failed by us, for which we blame each other community and each other perspective, both at the international and national level. Well, law and justice, precisely, if we want to define, it's very difficult because they are notoriously interrelated. Because whenever we employ law and justice, there are different connotations to different perspectives. What seems to be done is justice to you. What is made by me is justice to some other person. So in that philosophical context, whether it is common law system or Anglo-Saxon or civil law system or Anglo-Germanic perspectives, or whatever the perspective of law that we take in with respect to various aspects of the conduct of life that we think of dealing with various aspects. All these aspects of law and justice is mainly connected or interrelated with the important perspective of regulating human behavior, which is linked with the righteousness and the spirit that is to be shown in the activity of this, which is definitely or differently perfect or imperfect. Then when we broadly speak, integrity, impartiality, righteousness, fairness constitute three important aspects of attributes of justice. Well, how far are we able to achieve integrity, impartiality, rightness, fairness in doing justice? That's the million-dollar question, which is at crossroads, both in the international jurisprudence and in the municipal jurisprudence. The province of mandate that has been given to law and justice, or particularly the domain of justice, is concerned with what law is. It's not concerned with what law ought to be or ought not to be. It's concerned with what law is to be or is to set out the facts that is to be addressed with respect to doing justice to the people in the paradigm of righteousness, impartiality. In these two access points, justice revolves around by itself with the various perspectives both at the international and national level. And when we segregate and we bring in these perspectives, then we have to disjoint, we look at law and justice as a disjointed perspective and not a jointed perspective. That's one of the major issues that is continuously debated and led to deal with various aspects. When that being the system, the multifaceted international society, well, trying to draw a balance between law and justice. Professor Richard Falk has rightly observed that nation states and individuals have to join together to work hard. What for? To have a stronger mechanism both at the national level and the international level, to remove the barricades that have been put in for the development of the perceptions of law. So Richard Falk was very, very clear in his perception. Well, after Richard Falk, another important scholar whom everybody thinks and discusses, the great American philosopher who made a very impact on the changing dimensions of justice and introduced the modern concept of globalization. I'll come to globalization. Globalization is not a new concept. It is as old as the civilization. Because it is John Rawls, the American philosopher, has made a very beautiful impact, because John Rawls developed his principles on the democratic ideals, wherein the actors of societies to be cooperative and develop the rules and regulations to mutually accept the principles of fraternity that have been to be brought in and to nurture equality and liberty. Well, when these principles have been imbibed among all the scholars, John Rawls could make an impact, because the Western philosophy in the beginning concentrated on rights perspective, but not on the duties perspective. The Eastern societies have concentrated on the duties perspective, particularly India, China, the Buddhist philosophy in Asia has concentrated continuously on the duties perspective. That is the reason why the Indian principles of Dharmo Rakshita Rakshitaha is the first duty-based principle, is protect law and justice all the time. Law and justice will protect you. Unfortunately, in the modern era, when we speak Dharmo Rakshita Rakshitaha, people will say, it is Brahminical, sir. I don't understand. Without knowing the meaning, people speak, because we got independence 75 years back. On paper, but not in practice. Because though colonialists have gone from India, the kind of colonialism that has been inculcated in our minds is still persistence, and our brains have been spoiled by colonialism, and we have still not come out of the colonialistic bent of mind. This is what the Malaysian Prime Minister long back has advocated, that we don't want the colonialistic bourgeoism or anything into our Eastern societies. Muhammad Mufti, the Malaysian Prime Minister, long back has advocated. The Singapore government also has advocated that these perspectives we don't want. Because why I'm advocating, John Rawls' conception, first though advocated duty, the philosopher realized that, oh, Rawls talking rights is something. So if you see John Rawls' beginning works, which only concentrates on rights, but later his theory of justice, he advocated 2 specific chapters on duties. And under the duties, He advocated the concept of duty is applicable to individuals at the municipal level and at the international level to the states. Why I'm talking? Globalization, global perspective of law and justice became more famous only because of the important principles that have been brought in by John Rawls. Unfortunately, the perception of John Rawls has been misunderstood by many scholars, including Amartya Sen, his own student. Amartya Sen, in his book on justice, has dealt more on economic perspective, but didn't link with economic justice and started criticizing John Rawls failed. John Rawls has not failed. Amartya Sen failed because he has thought only economic perspective, but not economic justice perspective. Whereas John Rawls advocated economic justice is the most philosophical tenet. So John Rawls is misunderstood by the scholars because he has advocated two important principles. One particular principle is to eliminate all kinds of discrimination, both at the national and international level. And the second is to bring in coordination of fraternity, equality of distribution of resources in the field of politico-economic, trade, cultural relations. That is the perceptions. These are the background semantical perceptions. If we can look in, then we will be able to understand the conceptual perspective of globalization, law, and justice. Three interconnected aspects. And notoriously misunderstood at every point of time. As Richard Falk has said it, they are notorious to each other because each has its own dimensional perspective, each has its own stringing point of view with respect to various aspects. If we look into globalization, well, the concept of globalization is as old as human history. Recently, when I was reading the works of a British anthropologist, it was surprising that he said globalization started in 3000 BC, not now. He has his own justifications. He has given, I don't have time to delve in, he has given each justification how globalization started in 3000 BC. Then another historian from Britain, he said, no, globalization has not started in 3000 BC. That is a misconception. But globalization has started in 10th century AD. And it's true after the downfall of two powerful nations in the world, that is India and China. Particularly the downfall of South Asia. We always read Western society, Western civilization. We have been painstakingly taught to read European history, World War, crime. Even our legal history classes, we teach Minto-Marley reforms, regulating act, but we don't teach our own Indian philosophy or history, which has conjointly, concomitantly combined with the present fourth phase of globalization, that is economic globalization. Unfortunate that Indian law schools, Indian law professors failed to study, Indian historians have dealt in, but we have not brought in those principles of economic justice of India that has been culminated right from ancient periods into the modern, as Madam Visalakshi was telling, the interlink between human rights and business. And we all talk human rights and business because UNEP and United Nations Human Rights Commission and United Nations Human Rights Council has linked it. So it's a new concept. But if we read it, Jimotavahana's code of Vyahara-daksha, Vyapara-daksha, Vyahara-daksha, Vyapara-daksha, both are one and the same, of course. The Vyapara-daksha clearly enunciates it in chapter 16, the principles of duties of commercial merchants who have to follow in their trade and societal perception. It's nothing new. And the interrelationship between human rights and business is as old as human history in India. It's only the West should know. Now, since West says, we say, oh, it's fine, it's fine. And globalization is a myth. Globalization is nothing new. It's a perception of a common brotherhood, communitarian perspective, which we have to advocate and understand under the various aspects of the prescription. Well, the first phase, whatever it may be, the historical antecedents, the globalization is started, according to the latest scholars, at least in 1900. So they advocate that various perspectives. The first three phases of globalization in the modern context has concentrated in reforming law and justice at the international level. That's why all these happenings that took place right from the Peace Treaty of Westphalia to 1945 UN Charter, that has reformed the various perspectives. After that, a long-drawn intervention of international perspective of international relations has brought further reform in the end of third phase of globalization, is the draft charter of UNTAR and the various perspectives of trade and trading relations, and the new international economic order, and the United Nations Declaration of 1974 of exploration and exploitation of the resources. And then the most important perspective that is being opposed by the West, that was advocated in 1978 in the General Assembly session by the modern father of international law, Arvind Pardo, common heritage of mankind principle. That sharing of resources and other things. Why I'm talking this? Because though the United Nations Charter or the Universal Declaration of Human Rights are popular and participated everywhere, the concept of social justice is missing. And the concept of social justice has been imbibed in the Indian Constitution thanks to the constitutional framers. And what are all there in the various perspectives, which has been authored by the mother of the Constitution of India, the preamble, that is Dr. Babasaheb Ambedkar. And we read justice, liberty, equality, fraternity to achieve social justice as stated in the preamble. But we didn't understand the cooperative principles of federalism, both at the international level and the national level, has to be followed, which Dr. Ambedkar clearly enunciated. Today in India, cooperative federalism is withered away. Because many of us think that an American professor called the Indian Constitution is quasi-federal. It's unfortunate law professors also teach Indian Constitution is a quasi-federal. But Indian Constitution introduced the concept of cooperative federalism, the first constitution in the world which introduced a cooperative federal constitution, taking into the principal clues of globalization that has been started long back. Globalization is not a new concept, my dear friends. It's only myth. It's only we think of global village. You can't create a global village. When you can't create a national village, how can you create a global village? Because the conception of equality, non-discrimination, cooperating, and the principles advocated, even our own preamble, we misunderstand. According to the drafting committee chairman, Dr. Babasaheb Ambedkar, the preamble should be read not from the above, from the below. That is, first you should have fraternity. We don't have a fraternity in India today. Each pulls the other every day. And the bloody news channels clearly advocate various principles, other various aspects, all Duncan stuff to us. And we think that is only the news. So when we think of fraternity, then only equality, then only justice, then only liberty, then only justice. See how deeply they are interrelated with each concept. When we think of all these principles, social justice comes in. So the paradigm, because I've seen the flyer that is being given for the seminar, they have identified very excellent aspects, but all these aspects are to be interlinked with these two concepts of social justice and economic justice, without which we cannot. You have right to education, right to women, right to vulnerable groups, right to health, right to health again if we talk Article 12, intellectual property rights if you talk Article 15 of the International Covenant on Economic and Cultural Rights. Will we deal with the social justice is a relative concept. It's a concept that has been developed out of surroundings of industrial revolution, the advent of the socialistic pattern of society in order to create an organization of society. It's a concept deeply rooted on the ethico-moral principles, but some of the scholars argue that it is a concept, social justice is a concept that is tenuously rooted in the Anglo-Saxon political culture. Anglo-Saxon political culture is very new, maybe 100 years old or 200 years old. But the social justice paradigm of cooperative federalism of India or Asia is advocated since long. So economic justice is unquestionably as an important perspective of globalization. When we talk of, because today I see of late for the last 2 years, everybody talks pandemic, COVID. Pandemic is not a new concept to international law. Pandemic is a centuries-old concept in international law. International law has all principles for the nation states. Developed principles are there, but nobody knows what international law, international relations. Unfortunately, in India, we don't teach international law. In LLB class, passing cloud of international is taught. Because we can't match with international law. As John Westlake said, international is always a century ahead of us. It has developed the principles. We have to understand the principles to apply to modern context. So when we take the financial transactions, progress, various relations has to be taken into consideration. When we take up all these principles, the concept of social justice and economic justice, which is linked with the law and justice to achieve in a globalized world, a fair, efficient, progressive taxation system is required, either at the national level or at the international level. Because today, in the whole world, we talk of corruption. Particularly in India, we talk corruption is so much in government jobs. And news channels, whenever a small DA or a salary hike is there for employee, they highlight, our employees are getting so much money. But how much unequal taxation that are giving? You ask Professor Bhatnagar or any employee who is a vice-chancellor drawing, how much taxation that an employee of a Group 1 officer is paying? 33%. Whereas an industry pays 25% under the present government. Is it the equality of taxation, equanimity of taxation? And our finance minister say, you are getting more. And an employee who doesn't get 4 months salary or living wage, then corruption will be there. You can't root out corruption. This is one of the important principles. This was not their part of international jurisprudence of justice and liberty. But the Copenhagen principles, the Copenhagen Declaration on Social Development has included that fair taxation, either at the international or at the national level, including the supply chain of market and goods, have to be compensated with respect to public services that need to be taken into consideration. Well, social justice requires a strong, coherent public policy and multitude of areas like fiscal, monetary, other economic policies, well-knitted social policies. Specific objectives must be towards social goal of promoting welfare. These are the important principles of globalization in this economically globalized era. When you achieve these principles, the notorious twin brothers, law and justice, will able to do their justice part. Otherwise, they cannot. We always say law and justice are always failures, sir. Law and justice has not failed. Law and justice never fails. They have not yet won because we have not established a cooperative economic federation or either at the national or at the international level. You establish, you see law and justice, how they will act as the tools for the society. Because social justice has understood that the fair, compassionate distribution of resources, that's economic growth, is to be distributed. This is what advocated in 60s, 70s, 80s in international law. Now we are advocating at the municipality, municipal level, at the municipal legal perspective. Because Article 1 of the UDHR, which advocates that all men are born free, equal with dignity and rights. And Article 2 more specifically advocates everyone is entitled to the rights, freedom set forth in that declaration, which have to be promoted, nurtured, realized, and the most important conjunction clause is to be enjoyed without race, color, sex, language, religion, political, or any other platform. When these principles are there, either at the national level, or at the social origin, or at the property level, or at the birth, or at the status of the individual, you can think of talking of law and justice. So, my dear friends, the changing dimensions of law and justice is to look at, to evolve the equality and equality of various perspectives. Well, before I end it, I will say there are 3 important and 6 ingredient principles of social justice, economic justice, that are linked with law and justice in the changed era, which leads to number of issues. No question of emerging issues. Issues doesn't emerge. As long as we don't able to achieve economic equality, economic fraternity, well, the principles, whatever you talk, will be emerging for you, but they are not emerging, they're not addressed. That is equality of the opportunities, which requires a stable social environment, a cultural philosophical conditions, enable to the individuals to fulfill their potential to contribute to the economy and to the society. Do we have equal opportunities? Well, we have to answer this question is a $1 million question. Equality in living conditions for the individuals. Do we have equality of equal living conditions? Urbanization is made, agriculture is relegated to a secondary position. We convert agricultural lands into urban industrial lands. Well, where do you get food? Where do you get the living conditions equally? That is equal income, equal wealth in the society, and the various general agreemental principles, that is justice which is fair, justice which is to be fair, law which is to implement the fairness of justice, are at crossroads. I don't know they are at doldrums or at crossroads, because we have not evolved universal norms to be applied. We have not dealt in, because we don't have equality to contest even in elections. Today, in many parts of the world, including India, in many political parties, there is no voice, there is no democracy in the political parties. Even in America, we look at dollar currency, but we don't look at the backside of the American, because right now, the Ukrainian crisis is a major example. Russia wants to regain its superpower status. And 1/4 of the oil and one half of the gas supplied in the world is controlled by Russia. And if that is not been taken care, and the Ukrainian crisis, you take it for granted, Mr. President Putin will not going to declare a war at all. At all. It is America's hypothetical imagination. But Putin's idea is different. By creating exerting pressure on Ukrainian crisis, and the markets have collapsed, the economy is collapsed, and many economies will collapse, even European economies will collapse, particularly thanks to the COVID scenario, then regain its power in the market. We are going to pay huge price of these crises, particularly the depending countries which have not exploited their own resources. We consider sea as a dumping ground. We don't consider environmental friendliness of the law of the sea, where the flora and fauna is there. Unfortunate. And we talk of environment. We don't promote environment. Noise. One of the important environment silent killers. We bombardly use the noise. For every meeting, every function, speakers, this, that, every day, loudspeakers, horn, buzzers, this, that, buzzing sounds you get. And that, why I'm talking, this type of negligences that are taken in the developing world are contributing more to the sustainability of economic viability of the 6 important principles, which I will be just stating to you. I will leave it open because the seminar may discuss, may throw light on these circumstances. I don't know how many have realized that this conception of social justice and economic justice paradigm is part of economic justice in their papers. The 6 important principles that have to be addressed in the globalized world, where the changing perspectives of law and justice have to address, are inequalities in the distribution of income, inequalities in the distribution of access of assets, including assessments not only property, physical assets such as land building, and stronger, longer resource assets, that is sharing of resources. Inequalities of the distribution of opportunities for work, including employment and also equal opportunity to participate in social and cultural life and political life. And many of political parties, particularly in India, are now family-ruled political parties. You don't have a voice. We are seeing that. Then what are you talking of law and justice? And what are you talking of law and justice changing dimensions in a globalized world? Globalization is a myth, it is not a concept. It is there right from generations. It's only a buzzword since 1990s. An American scholar named it as globalization. Everybody thinks, oh, it's a new concept. It's nothing. It's a very, very, very old concept. It's never called as globalization. It is called as a cooperative economic achievement. That is the reason why Gandhiji has advocated Swaraj principle on the basis of common economic principles. Inequalities in the distribution of opportunities, inequalities in the distribution of access to knowledge. That's another important perspective. Inequalities to distribution of health services, social security, provision, safety, and environment. Inequalities in the distribution of opportunities of civic and political participation. That's the very important. Then these 6 inequalities have to be come out. Well, law and justice will able to do the justice perspective. Then what the role that we the legal teachers, we the legal students, we the law universities have to do is to culminate, not to teach. Unfortunately, we don't have freedom. The Bar Council of India, what we, myself or Bhatnagar or his parents or his father's father studied 28 papers. We study those 28 in addition to another 28, 56 papers. You are given an honors degree without knowing what is the perception of law and justice. Then we go and practice, where a student will not get even an income for 5 years, 10 years, and they go for corporate clerks. Then coming to the bench and bar. Then what type of justice, what type of settlement of disputes, what type of perspectives that we can argue or we can nurture in this perspective of various issues that we tackle and deal with it in the world or at the national level or at the international level. I appeal, I thank Dr. Bhatnagar for taking the initiative. It's a lively topic. It's a very challenging topic. It's a very interesting topic, but I think if Professor Bhatnagar agrees, I'm there ready that we can bring series of lectures and series of papers on what Professor Lakshminath started in the Chanakya National Law University and what half late some of the honorable judges of the Supreme Court started advocating. Work at the ancient legal jurisprudence that has been created to come out of the colonialistic drastic bent of mind of Britishers who taught us painstakingly 200 years that your culture is bad, your literature is bad, and to end that and see that the changing dimensions of law and justice in the globalized world will revive the Indian ancient culture that India is the richest country in the world again, either in knowledge front or in the work front or in the social life or in the cultural life or in the political life. Thank you, one and all. Thank you for giving me the opportunity.
Thank you, sir. This was very valuable. Now we would like our chairperson, Dr. Prem Kumar Gautam, sir, to say a few words.
Thank you, Sachika. I hope I am audible to all. Thank you, Professor T.S.N. Sastry, sir, for your enlightening words. Good morning to one and all. Respected Honorable Professor Subir K. Bhatnagar, Vice-chancellor Dr. Manohar, Lohiya National University, Lucknow. Respected Honorable Professor T.S.N. Sastry, sir, founding Vice-chancellor, Sikkim National Law University, Gangtok. Respected Dr. V. Visalakshi, Head of the Department, Dr. Manohar, Lohiya National Law University, Lucknow. Respected Dr. Bodhisattva Acharya, distinguished faculty members, participants, and dear students. I would like to express my gratitude and warmly welcome you all on behalf of the seminar committee on this 2 days virtual national seminar on emerging issues in the law and justice in the perspective of globalization. I would like to convey my heartfelt gratitude to Justice A.R. Masoodi and Professor T.S.N. Sastry for accepting our invitation. I would also like to express my heartfelt gratitude to Higher Education Department, Govt of Uttar Pradesh for supporting the seminar. It is an opportune moment to refurbish and debate upon the idea of justice in the context of globalization and explore how the law may truly facilitate justice in the global world ravaged by a vicious pandemic. The seminar schedule presses upon a spectrum of exciting and benefiting themes that discusses the different aspects of law and justice in the perspective of globalization. The various sub-themes focuses on globalization and governance. They examine the issues and challenges posed by a border and movement during the COVID-19, which we have seen, and they also study the power of the state to implement special measures to stop the infiltration and need to safeguard the basic rights of the refugee, asylum seeker, and migrants. One of the sub-themes, and that is very important, that is the counters of right to health. And it's very relevant in the today's context, because it has been said that the Supreme Court has not yet articulated the full counter of the right to health in a manner that is analytically well structured and theoretically coherent. I'm sure the papers on each sub-theme would enlighten all of us. On behalf of the seminar committee, I congratulate to all the research scholars and paper presenters from various parts of the country who have made it to the seminar. I would like to put forth before our guests and participants that we have received around 55 abstract and 23 full papers. These research papers will be presented by the participant in 4 technical sessions based on 4 main sub-themes. And these themes are protecting the right to health, issues and challenges, human rights in a global world, contemporary issues and challenges, universalism and global governance, and educational accessibility and the impact of pandemic. In the last but not the least, I wish to express once again my gratitude to one and all present here, especially Professor Sastry sir, who taken out time from his busy schedule and shared his valuable knowledge with the participants. I wish a very fruitful and productive seminar to all. Thank you.
Thank you, sir, for your wise words. Moving ahead, I would like to call upon the convener of the committee, Atri Tripathi, to deliver the vote of thanks.
Thank you, Sachika. Good afternoon to Professor Subir Bhatnagar, Vice-chancellor Dr. Manohar, National Law University, Professor T.S.N. Sastry, Vice-chancellor NLU Sikkim, Dr. V. Visalakshi, Head of the Department of Dr. Manohar, National Law University, and our most valued invited guests, ladies and gentlemen. I am very humbled and honored to exchange the gratitude on behalf of the organizing committee and on my personal behalf in such a distinguished and intellectually stimulating gathering. My very special thanks to our Vice Chancellor, Professor Bhatnagar, for taking out some valuable time from his busy schedule and present his insightful views on the topic. I take immense pleasure in extending my sincere thanks to Professor T.S.N. Sastry, Honorable Vice Chancellor Sikkim National Law University, who has delivered the keynote address and set the pace for this national seminar. I extend my heartfelt thanks to one and all who have helped me to and this committee to make this inauguration ceremony of the national seminar a vibrant one, which would have immensely motivated the participants for further academic discourse. At last, I would like to thank our chairperson, Dr. Prem Kumar Gautam, our faculty members, Dr. Mitali, Dr. Abdullah, and Ms. Priya, and all other committee members for their requisite contributions. We hope to conduct this auspicious academic seminar with full zeal. To conclude, let me once again reiterate my gratitude to all. Thank you.
Well, since there is a time, if anybody wants any clarifications, I can give.
Atri, I think you just go through the
Professor
chat.
Bhatnagar, it's okay what I spoke.
Anybody wants something?
Thank you, everyone, for taking out your precious time, and we hope that you have a delightful experience in the two-day event. Thank you all.
Ma'am, I have one question to Professor Dr. T.S.N. Sastry, sir. Thank you very much, sir, for your these intellectual inputs. Sir, I just want to ask one thing. Sir, can you just give me some idea about Bharatiya jurisprudence, which you have just mentioned? Thank you, sir.
Understand? I don't understand your question. Please make it clear.
Sir, I just want to ask you that in your lecture, in the last part, you had said that Indian ancient jurisprudence has an important part in future law and justice. So can you, sir, just give me idea that what is this ancient Indian jurisprudence and what is its importance?
Well, nobody can give an idea about Indian jurisprudence or any jurisprudence. One has to read and acquaint by themselves and to understand the philosophical connotations. It is this is the problem in India. If anybody talks on something, people catch that and say that you are talking this, you are talking this. It's a holistic perspective, and the jurisprudence that has been advocated, the Indian jurisprudence is advocated on the duties perspective. And the duties perspective has been of late realized by the Western countries. So the advanced jurisprudence that has been destroyed by the Western culture should be revived. And that will give you the idea to achieve the concept of cooperative federation, because the constitutional goals and the constitution has been drafted not on Western ideology, but on the Indian ideology. But we fail to miserably understand the constitutional ethos, and we say that constitution has failed, and we amend every day, and we made more than 103 amendments, and we will soon make 200 amendments also, the milestones of amendments of Indian constitution. As the chairman of the Constituent Assembly, Dr. Babu Rajendra Prasad said, the best constitution ever produced on the earth is, I have my own reservations that in its implementation, because as Dr. Ambedkar made it very clear, if you have a bad person to sit in the ruling prism, you will have bad prisms. It's a common saying, not only Ambedkar, it's an Indian philosophy. If a good person sits there, you have a good augmentation. So unfortunately in India, what happens, any speaker speaks, one or two important points have been highlighted. Oh, you have spoken this, and this professor speaks only this. The Jewish students, what I'm speaking is not Bharat Jewish students. It is a globalization, where globalization requires, in the seminar title, please don't go out of the seminar purview. The seminar is in globalization perspective. The changing perspective is that what I advocate is equality, liberty, justice, fraternity with respect to social justice should come forward to be the henchpins of the tools of law and justice to realize the prime goal of equality, fraternity, justice, liberty, and social justice concept, for which the South Asian Jewish students or the Eastern Jewish students has developed. Unfortunately, many law students doesn't know the difference between Western Jewish students and Eastern Jewish students. Eastern Jewish students is much more advanced than the Western Jewish students. And when we are unfortunately in the Western influence, because the West ruled the whole world, and today America is talking of rights and imposing. For example, America says to India that if you join in the Ukrainian crisis with India, I will impose sanctions. Who are you to impose sanctions? We are a sovereign nation. That is what John Rawls has advocated. We don't read the philosophical perspectives. We don't understand. Unfortunately, today's society has failed mostly is because either at the international or national, the misconception or misunderstanding of the principles of law and justice.
Thank you very much, sir. Thank you, sir.
Have anybody any doubts? I can clarify them. Hope Professor Bhatnagar, it's okay within the contextual perspective.
Yes.
Thank you, sir.
Yeah.
Thank you, everyone.
Okay, thank you very much, Professor Sastry, for giving your
Thank you.
Or inspiring lecture address. Thank you. Bye-bye.
Thank you all.
Thank you, sir.